The rules have recently been updated with significant new immigration regulations approved by Congress that will impact millions of green card holders throughout the United States. And if you possess a green card or are in the process of obtaining one or know individuals who do, the information that follows may determine whether you retain your status or risk losing all that you have built, as these updates are substantial. They are taking effect immediately and cannot be overlooked. Welcome to VisaPulse USA, your reliable resource for precise and current details on U.S. immigration matters. Today, we are examining the recently enacted immigration rules passed by Congress, and in particular, their effects on green card holders. This is based on verified developments that are now active or will be shortly. Remain attentive through to the conclusion, as we will outline a straightforward plan of action you should take without delay to safeguard your immigration. Standing here at VisaPulse USA, we ensure you remain prepared for any shifts in immigration policy. Allow us to begin with the overall context. Congress has enacted a broad immigration reform initiative that incorporates multiple measures directly aimed at green card holders. The intended purpose is to bolster immigration oversight, detect fraud, and confirm that green card holders fulfill their legal responsibilities. While certain updates may be viewed as appropriate, others are raising substantial worries within immigrant populations. We will review each primary update individually to provide clarity on the developments. The first major update involves more stringent physical presence standards. This is likely the most impactful update and will influence the greatest number of individuals. According to the updated provisions, green card holders are required to demonstrate a greater level of physical presence within the United States. In the past, the common guideline allowed absences abroad of up to 6 months without endangering status, with trips shorter than 6 months typically considered secure, and prolonged absences over 1 year, raising abandonment issues. Unless a re-entry permit was obtained, the updated provisions restrict this considerably. Green card holders are now obligated to remain physically present in the United States for a minimum of 6 months within any 12-month period, meaning that spending over 6 months annually outside the country places you in jeopardy of being determined to have relinquished permanent residence. However, the complexity increases as the provision also examines a 3-year ongoing period, if more than 18 months have been spent abroad in any 3-year span. Officials may challenge your genuine intent to reside permanently in the United States. In practical terms, if you frequently travel for employment, have family commitments overseas, or own property in another nation, exercise extreme caution. Maintain thorough documentation of every journey. Retain boarding passes, passport entries, hotel invoices, or any evidence verifying entry and exit dates from the United States when contemplating a lengthy stay abroad. Consider submitting an application for a re-entry permit prior to departure. This permit permits absences of up to 2 years without relinquishing status, but the application must occur while you are physically present in the country. The second update concerns compulsory biometrics renewals. Every green card holder must now refresh biometrics with USCIS every 5 years, including fingerprints, photos, and signatures. In the past, this occurred solely upon 10-year green card renewal. Now it is mandated every 5 years, irrespective of card expiration. You will be sent a notification from USCIS instructing attendance at an application support center for the biometrics session. Compliance is essential. Failure to appear without valid reason may result in revocation of your green card. Indeed, revocation. This is a critical matter, not merely procedural. The authorities may end your permanent residence standing for non-adherence. If you have relocated without notifying USCIS, you may miss the notification. Thus, it is vital to update your address via Form AR11 within 10 days of any move. The third update involves intensified ongoing criminal history reviews. Green card holders are now under continual criminal background monitoring, not limited to citizenship applications. This is perpetual oversight. Any arrest, even for minor infractions, will be reported automatically to USCIS via interagency data exchange. Specific offenses may trigger deportation proceedings despite permanent resident status. These encompass crimes involving moral turpitude, serious felonies, domestic violence, drug-related crimes, and weapons offenses under the updated provisions. The criteria for initiating removal have been reduced. Offenses previously possibly disregarded are now under greater examination if you possess any criminal record. Even dated or sealed, seek advice from an immigration lawyer promptly to assess potential exposure. The fourth update requires proof of tax adherence. Green card holders must now demonstrate submission of U.S. tax returns and payment of obligations. The IRS and USCIS are exchanging data more broadly upon green card renewal or citizenship application. You must provide tax records for the prior 5 years, confirming filings and settlements if taxes have not been filed. This poses a major issue. Permanent residents must report worldwide income annually, even when residing abroad. Non-filing may lead to penalties as well as immigration repercussions, such as citizenship rejection or removal initiation. If delinquent collaborate with a tax expert immediately to achieve compliance, the IRS offers options for those previously non-compliant. It is preferable to resolve this proactively. The fifth update extends public charge evaluations to current green card holders. Traditionally, this applied to initial applicants, but now it influences existing holders as well. Receipt of specific public assistance, such as cash aid, food stamps, Medicaid, excluding emergencies or housing subsidies, may be factored in during citizenship reviews or status examinations. This does not guarantee automatic loss of status, but it may be used adversely. Authorities could claim likelihood of primary reliance on government aid if utilizing benefits record the reasons. If due to short-term job loss, health crisis, or unavoidable situations, compile supporting proof, demonstrating efforts toward independence. The sixth update broadens deportable categories. Congress has introduced additional grounds for removal, including provision of material aid to terrorism, even unknowingly, false claims to citizenship, even inadvertently, and unauthorized voting in federal elections, even if believed eligible. These are strict with minimal allowances for unintentional errors. Exercise caution with all documents if a citizenship query appears, respond accurately, avoid indicating U.S. citizenship when holding only permanent residence. This occurs frequently, particularly with voter forms, where options are selected hastily. A single error may lead to deportation. The seventh update alters citizenship processing for green card holders applying for naturalization. The interview has been greatly lengthened. The civics exam now covers more difficult topics on history and governance. English proficiency standards are heightened with reduced flexibility for seniors or disabled individuals. Moreover, the interview probes deeply into your full period as a permanent resident. Inquiries cover travel history, work tax records, family ties, and law enforcement contacts. They seek discrepancies between statements and records, prepare thoroughly, provide supporting documents for all application details, avoid speculation or approximation if uncertain state. So rather than fabricate, the eighth update permits faster removal in specific cases. Formerly, green card holders facing deportability were entitled to a judicial hearing with options for relief. The updated provisions enable expedited removal without complete hearing for those convicted of serious felonies or deemed security risks. In such instances, rights are severely restricted. Most relief forms are unavailable, appeals are largely barred, decisions and enforcement occur rapidly. Thus, it is essential to evade any criminal conduct entirely. The ninth update restricts reentry permits for prolonged absences abroad previously. Permits valid for 2 years could be renewed upon return, now limited to one per 5 year span, if frequent long trips are necessary. This poses challenges you may need to reassess whether retaining permanent residence aligns with your circumstances. The 10th update involves Social Security data cross verification. USCIS now compares records with the Social Security Administration, identifying those not employed legally or not contributing. Taxes, informal work, or improper Social Security numbers will be detected, resulting in potential deportation and fraud charges. Now, regarding protective steps, first for travelers, maintain precise records, develop a tracking sheet for each trip, noting departure and return dates and purposes, retain all related documents should presence ever be questioned. You will have evidence. Second, ensure your address remains current with USCIS submit form. AR11 each move. This brief process can preserve your status. Missed notices due to outdated addresses lead to lost opportunities and penalties. Third, submit tax returns annually, regardless of owed amounts, location, or income. Retain copies and records. These will be required for citizenship. Fourth, attend every USCIS scheduled session, whether biometrics or interview. If unavoidable, reschedule promptly with justification and proof. Do not ignore. Fifth, refrain from any criminal involvement. Even minor matters can trigger issues. Avoid impaired driving, altercations, substance use, petty theft, or fraud. Any arrest may initiate problems. Sixth, if facing charges, retain both criminal defense and immigration counsel. They must coordinate as certain resolutions favorable. Criminally may harm immigration prospects. Seventh, never provide false information on forms or in interviews. If prior errors exist, correct them immediately. Truthful corrections may be excused. Intentional deception leads to lasting bars. Eighth, if receiving benefits, document necessity and progress towards self-reliance, such as job searches or medical recovery plans. Ninth, foster U.S. connections, maintain banking accounts, driver's license, tax filings, property or family ties. These demonstrate true, permanent intent. 10th, pursue citizenship if eligible, after 5 years or 3, if married to a citizen and meeting criteria. Once naturalized, most restrictions cease. Deportation is rare. Travel is unrestricted. Without presence, concerns. Common inquiries include whether these can be legally contested. Yes, advocacy groups have initiated challenges. However, until overturned, they remain enforceable. Comply now rather than await outcomes. Exceptions are rare, applying broadly, regardless of acquisition method. Family employment, asylum, or lottery pre-enactment violations generally avoid retroactive penalty, but ongoing issues like tax non-filing require immediate correction. Loss of status is possible even without wrongdoing. Simply for failing new mandates, such as biometrics updates, these measures received cross-party congressional backing, emphasizing greater accountability. Though concerns persist about severity and uneven effects on communities with overseas duties, family care, or limited resources, future discussions suggest further shifts, like conditional status, periodic renewals with eligibility proof, higher fees, or restricted waivers. Accommodations exist for elderly or disabled in biometrics or testing, but narrowed vigilance against fraud is advised as changes. Prompt exploitative offers consult only licensed professionals or accredited entities. In summary, these updates mark a profound evolution in treatment of green card holders' ongoing duties, and oversight are now standard. Compliance is key, given the high risks. Thank you for joining VisaPulse USA. We trust this has clarified the new rules impacting green card holders and necessary protections. If helpful, subscribe to VisaPulse USA and enable alerts. As immigration evolves quickly, we are dedicated to keeping you updated. Share this with affected individuals. Questions or worries about these updates may be posted below. We review and address as many as feasible. At VisaPulse USA, We aim to equip you with essential knowledge for successful navigation of the U.S. immigration framework. Stay updated, stay adherent, and secure your standing.